Thank you, Mr. Chair. I've got a series of questions, so if I could have a little room to follow up, I'd appreciate it. I got a little confused talking about the transition from before the 1945 Supreme Court case was handed down sometime in October, and how you were evaluating workplaces before and after that, because in response to the chair's questions, it sounded like you're saying that you didn't just treat a violation of the governor's emergency orders as a per se violation of the general duty clause, but we're relying on other sources for that decision as well. So why wouldn't you just keep doing that after the Supreme Court case came out? Does that question make sense? In other words, if you weren't relying so heavily on the 1945 law that you should be considering returning fines issued prior to that Supreme Court decision, why would you change to another source of authority?
We were asked at the time to develop the emergency rules to cover the workplace portions of the governor's executive orders. So that's what MIOSHA did.
Okay, so again, my question is, if you had to change your source of authority for the enforcement, doesn't the chair's question about returning fines prompt you to consider taking that action?
As I said, Representative, those citations are under appeal currently.
Okay, but I'm asking you if the administration is considering not forcing a party to go through an appeal process, but instead taking the Supreme Court's decision, striking down the 1945 Emergency Powers of the Governors Act as unconstitutional, as an opportunity to review its own enforcement prior to that date. Is the answer to that question no, you're not reviewing that? You're not considering whether that enforcement was inappropriate?
Not at this time.
Okay. Regarding the executive directive requiring the posting and publication of enforcement actions, is there a scientific study of some kind that supports doing that with COVID cases only rather than with other types of workplace hazards?
Not that I'm aware of.